So I want to welcome everybody tonight to our SALT Talks. This is for this season, the 2024-25 season. This is our last session tonight. So we are ending we're going to talk about guardianship tonight. Those who have been following along know that this month we've been tackling special needs trust, stable account, supported decision making, and now guardianship. They all and last month was Social Security, funding, like Medicaid funding, benefits, all about benefits, and they all kind of link together. And so we kind of had them in a block for the last 2 months. It's been a heavy couple months of information. But then you see how it all comes together as you finally discuss with guardianship, alternative to guardianship, anything around that. You see how things just start coming together with all these other topics. So tonight we have Brittany O'Dime, and she's going to be talking about the guardianship, powers of attorney, and anything dealing with guardianship. And we'll be taking questions through the chat box. So go ahead and put your questions in there as you listen to the presentation, and we'll address them. We'll be addressing a lot of the questions at the end, but I want to make sure that we get through the presentation tonight. At the end, we'll stop the recording the last 15 minutes, and we'll allow some discussion time and make sure we cover everybody's questions. So with that, I'm going to turn it over to Brittany, and I have you co-host so you can share your screen in the presentation.
Yep. Great.
Yep.
Well, thank you so much. Excuse me. Well, as Patty said, my name is Brittany O'Dime, and I am an attorney in Centerville, and we're with the firm of O'Dime and Estes Law Group. And as a firm, we really only focus on specific areas. So we do the entire spectrum of estate planning, from really basic wills all the way up through, the more complex asset protection and tax planning and everything like that. And we are able to dig a lot deeper into some of the more intricate areas, such as special needs planning. So we do a lot of special needs planning for our clients, whether it's planning for how our clients are going to be able to provide for their loved ones with special needs, or even helping our clients with special needs plan for money that they have and the preservation of their own benefits. And then within that, we do guardianships and estate administration, and a lot on the elder law side as well, with Medicaid benefits for long-term care and helping people navigate the maze that is all of that process. So that's what we do as a firm. There are 3 attorneys in our office, and we all kind of work as a team, and we all focus just on those areas and send everything else out because it keeps us happy and we enjoy the areas that we're working on. So I'm going to share my screen so that we can start on this presentation. So bear with me just a moment while I get this set up. All right. Just a moment here. Excuse me. Okay, can everybody see this okay? Perfect. Well, starting out, I want to make just, your typical disclaimer that this is not specific legal advice. I'm going to share a lot of information today, just kind of as an overview of the general guardianship process and things to be keeping in mind as you plan to, embark on this with your own family. But these are all very specific to your own unique circumstances, your own unique goals, and your own unique kids that you're planning for. So while this is really good general information, anytime that you're looking for advice related to your specific situation, I really encourage you to get together with a qualified attorney to help walk you through that. And our goal today, let me see, there we go. Our goal today is really to focus on the question of how do we create the best structure to allow someone to act on our behalf or on behalf of another individual, to help with financial and healthcare decision making. And there's different ways that we do that. So we're going to go through some of those different ways so that we can make sure that we understand what the options are and when one might be more appropriate than another. The 2 main options that we look at when it comes to this are powers of attorney or guardianships, and diving a little bit deeper into how those work and when one's appropriate. So our goals tonight are to go through, the basic guardianship rules, so that we understand what the process looks like, things that you should prepare for, timing of everything, so that you kind of understand a little bit more about when to approach this process, if that's the route that makes the most sense, and how that contrasts with powers of attorney, and how we might, just differentiate between one versus another as the better plan for your family. And then hopefully we'll dispel some of the myths and just general misunderstandings that might be associated with those things, so that you can walk in more with eyes wide open into that whole process. Big picture, when we're looking at how we approach all of this, you're going to hear me repeat this probably several times tonight, but everything that we're looking at, everything anchors around this one main idea. We must always be looking out for the best interest of the person that we're planning for. That is paramount across the board, and every analysis that we're putting under this. So we're not looking for what's easiest. We're not looking for what's cheapest. We're looking for what is going to serve the best interest of that person as an individual, not as a diagnosis, not as, a dependent or anything like that. What can we do to make sure that that person's individual well-being is protected? And that's going to look different at different levels. So it's not just, big picture. We're going to dig into safety. What is the best care setting for that individual? Is there the likelihood, or would it be safe to consider, an independent living situation? How do we plan and structure around that? Is there a better care setting if we have a little bit more hands-on assistance? Is it a group home? Is it home with mom and dad? Is it with another family member? But also why? We want to make sure that, what's the why behind that? Not just that it's the most convenient or the easiest to pay for. What is the best, what is the service that this setting is going to provide for that person? General well-being, we want to look at that they're financially secure with all of the programs that you've just talked about with Social Security and Medicaid, and all of the ABLE and special needs trust set up, that they're financially secure. But just as important is that their happiness and that their peace of mind and their general well-being is protected and provided for, that we're not just setting that to the side, because that is really just as important as physical health when it comes down to it, because that's their enjoyment, their quality of life. And then their independence. A lot of what we're going to talk about tonight is a little tricky, because it does contemplate taking away somebody's liberty to make their own decisions. And that can be really, really hard to discern. There's not a bright line, easy button, bright line rule or easy button that we can press to say, well, this is when you do it and this is when you don't. It's also not one size fits all. Sometimes in some situations, it's very clear that we really need to have somebody in place to make all decisions for this person, because maybe this individual is not capable of doing it for their own. But many people, there's a kind of a spectrum for what they're able to do and not do. And so we try to really tailor it to individual circumstances, so that we're not just carte blanche taking away somebody's liberty when there's really things that they could still manage on their own. So we try to take a much more in-depth look at all of that. My spacebar does not want to work to do these. Okay, there we go. We're going to start with powers of attorney, because I think this is a little easier to set up kind of the framework for the dichotomy between powers of attorney and guardianships. So there's a couple types of powers of attorney in Ohio. First, we have your financial power of attorney. A lot of times you'll hear this called a durable general power of attorney, or just a durable power of attorney. This is your general, hey, I trust this person to stand in my shoes and take care of really anything under the sun that I'd be able to do for on my own. They can be durable or non-durable. So what that means is a power of attorney is effective when I sign it. So if I signed a power of attorney today naming Patty as my agent, then Patty, as of today, could step in under the authority of that document and take care of what I need, if that's what the document says. If it's durable, that means that Patty's authority as my agent would continue even if I become incompetent, okay? So most powers of attorney don't require that I become incompetent in order for them to take effect. Most powers of attorney are what we call immediate powers of attorney. Yes, we might use powers of attorney more frequently because I've become incompetent, but most of them are written so that they are immediately effective when signed, and don't require that I become incompetent in order for them to be used. But they can still continue even if I do become incompetent because they're durable. Rarely you will see powers of attorney that are what we call springing powers of attorney. And a springing power of attorney is a power of attorney that in the document says that this agent's authority takes effect only if I become incompetent. And usually it'll set a standard in there for how that would be determined so that we know when that is supposed to happen. Springing powers of attorney, can be really helpful in the right situation. But the reason that immediate powers of attorney are used a little bit more broadly is that there are lots of situations where powers of attorney can become useful when somebody is not incapacitated, when they're not incompetent. Oftentimes it's perhaps that they're just unavailable, or maybe it's inconvenient to do something. So, hey, I might be traveling, right? So I always tell the story, my brother, when he was 20, he joined the Army. And when he was away at basic training, his identity was stolen. Well, we are the children of an estate planning attorney. So in our family, when you turned 18, it was happy birthday, sign your estate plan. We all got our wills, we all got our powers of attorney, all of that was part of our 18th birthday gift. And so when he joined the Army and he was away at basic training, his identity was stolen, but my parents were able to step in and immediately resolve everything with the bank because they had the authority to do so under his power of attorney. Had they not had that, I'm sure there would have been quite a mess to untangle because he wasn't able to be accessed at basic training and he wouldn't have been able to do anything from where he was. So that was really helpful. And then when he was on his first deployment in Afghanistan, there was a local car dealership that was running a special on trucks for active duty service members. And so he found it online and he built his truck to the specifications that he wanted while he was online and sent it all to my father. And then my father, while my brother's overseas in Afghanistan, purchased the truck in my brother's name. He used the power of attorney to purchase the truck in my brother's name. And when my brother came home from Afghanistan, we picked him up from the airport in his own truck. So it wasn't that he was incompetent, it was just that he was unavailable. And on his second deployment, he bought a house while he was overseas. My mom used the power of attorney, purchased a house in his name. We had him moved in and pictures on the wall and food in the fridge when he came home. So thankfully he got out of the military after that, because I'm not sure how he would have won up to that for a third deployment, but there's lots of times that we use powers of attorney because it's just more convenient, not because somebody is incapacitated necessarily. Powers of attorney can also be general or limited. So one thing that's really important to keep in mind with a financial power of attorney, it's not a one-size-fits-all thing. The power of attorney only does what the document says it does. Okay, so there's no standard language that says, oh, I'm power of attorney, so I'm automatically vested with all of these authorities. No, it's really whatever the document says it does. So even if I have a general power of attorney that purports to give me the broad authority to do anything under the sun, unless it's spelled out in there, there are certain powers that cannot be given without being expressly spelled out in the document. So oftentimes you see this in the context of, yeah, I've got somebody's general power of attorney, but do I have the authority to buy or sell real estate on their behalf? That has to be spelled out. Do I have the authority to create a trust, a special needs trust or a pooled trust or something of that nature on their behalf? That must be spelled out. Do I have the power to do gifting? Do I have the power to apply for Medicaid on somebody's behalf? This is an issue we've had really more frequently here in the last couple of years, that Medicaid, because of a mandate from CMS, Medicaid is more strictly scrutinizing power of attorney documents. And so if an agent is signing a Medicaid application on the behalf of a principal under their authority as a power of attorney, Medicaid wants to see that that power of attorney has a provision in there that says expressly, you may apply for Medicaid benefits on my behalf, and you may appoint somebody as an authorized representative on my behalf. And if that's not in there, then there are situations where we're having to go with guardianship if we don't have an individual who's able to sign their own application. So having a document say what we need it to say is very important. And this is where it's really critical to make sure you're working with an attorney who's not just filling in blanks on a form and is really counseling you through what you need and making sure that your documents are going to do what you ultimately will need them to do. Powers of attorney, so the other side of the power of attorney coin is your healthcare power of attorney. These are a little bit more broad. We don't have as many issues with the enforceability of healthcare powers of attorney. There is a state form for this. So the state of Ohio has a prescribed form for a healthcare power of attorney and a living will. That form is available through different places online. It's also available through most hospitals, and it has kind of the state standard language. Now, some attorneys, my office included, we use a little bit of a variation on the state form because there's certain aspects of it that we don't love, so we tweak it just a little bit to make sure that it's doing what our clients need it to do. But these are basically a way to name somebody to stand in your shoes and make any kind of healthcare decision that you could make for yourself, but only if you're not able to. So it doesn't remove any of your decision-making authority. It's just saying, if I'm not able to make a healthcare decision, here's who I trust to stand in my shoes and do that for me. So whether it's making a decision about a medication or a surgery or getting a second opinion or moving me to a different hospital or whatever might come up, they're able to stand in my shoes and take care of that for me under that healthcare power of attorney authority. Again, it needs to say what we need it to say. So oftentimes they'll look to make sure it has HIPAA waivers in it, so it's waiving the privacy rules. Oftentimes you'll find organ donation wishes listed in the healthcare power of attorney. You'll have specific provisions about the withdrawal of artificially supplied nutrition and hydration. So there's lots of things in there that take some thinking. And so it's important to kind of be counseled through those decisions and make sure that it's going to do what you ultimately need it to do. So powers of attorney are really great documents to appoint somebody to stand in your shoes and act on your behalf in those scenarios. But they're not without limitation. And this is honestly where we get a lot of our biggest headaches when it comes to these documents. So first and foremost, for these documents to be effective, the person that's creating the power of attorney must be competent to create them. So competency in this context is that person really needs to understand and appreciate what they're doing. So they need to understand what it means to name somebody as a power of attorney. I understand that by naming Patty as my agent, I'm giving her authority to do things the way that I could do them. And it's giving a lot of power there. I'm also appreciating the relationship I have with Patty and that she is somebody that I trust. And yes, I'm rationalizing through, yes, this is who I would want doing that. I maybe wouldn't want some stranger off the street doing it because I don't trust them, but I do trust Patty and I know that she is good in those areas. So this is where I'm going through my analysis. So as we are counseling people about powers of attorney, we go into a lot of depth of questions about, what the document means and learn more about their relationship with the people that they're naming as agents so that we can help gauge the capacity and make sure that they truly are making an informed decision and not just signing something because we're putting it in front of them, because that's ultimately not going to make a valid power of attorney. They must be properly executed, and these execution requirements, they're meant to be basically a safeguard to make sure that capacity issue is handled correctly. So powers of attorney, oftentimes they're going to be notarized. Ohio law does require a notary on a power of attorney. Sometimes you'll even see that they're witnessed. If you're using the hospital form of a healthcare power of attorney, there's a caveat that it doesn't have to be notarized. It can be witnessed if you're using the state form. But generally speaking, Ohio law says that a power of attorney must be notarized so that we've got somebody who is able to attest to the fact that yes, this person did sign this document, and yes, as far as I'm aware from what I observed when this all happened, this person was not under any undue influence. They understood what they were doing, and they appeared to have the capacity to execute this document. They also must have an agent who's actually willing to serve in that role. So just because I name Patty as my agent under my power of attorney doesn't mean that she has to do it. This is important because a lot of times we're preparing these documents with the intention that we're probably not going to use them for a while, right? So as a standard part of most estate plans, we're preparing powers of attorney for clients. And that power of attorney is likely going to be shelved for maybe a couple years. And only if something comes up where it's needed will we ever be testing it. So we might have people named that make sense to name right now, but 2-3 years down the line, they might be going through something in their life that they don't have the ability to step in and take on this role. So just because they're named doesn't mean they have to do it, which is why we always encourage clients to name a few alternates so that we have successors that are able to step in if somebody's not able to do it or not able to continue to do it even if they've started the role. One of the trickiest part about powers of attorney from a financial perspective, the financial powers of attorney, there's nothing in Ohio law that says that a bank or someplace like that has to accept them. Okay, so financial institutions do get to choose whether or not they accept your power of attorney. And it is a fun little game that we play because, excuse me, every bank looks at it a little bit differently. So there's no standard process that a bank needs to follow. There's no standard criteria that need to be met in order for a power of attorney to be enforceable with a bank. So they get to look at it and decide on a case-by-case basis whether or not they'll accept it. It has always been like that, so this is nothing new. But what is new is that we're seeing a trend, especially over the last few years, that banks are getting more and more strict about when they will accept a power of attorney. I think a lot of that has to do with people misusing powers of attorney, which unfortunately can be a really big issue as well. So they're trying to protect against that, but in many cases they've almost swung the pendulum too far the other direction and made it difficult to use them, even in legitimate circumstances. So like I said, there's not a whole lot of rhyme or reason on this. Most of the banks will tie their rules to the age of the document. So they'll say, well, this power of attorney was signed more than 3 years ago or more than 5 years ago. Or recently I had a bank that told us, well, it was signed more than 6 months ago, so we can't honor it. And it was 6 months and 1 day old. So even though that seemed a little ridiculous, we were at their mercy and there was nothing we could do to force them to accept it beyond that. Now we find that well-written powers of attorney are much more likely to be accepted than some of the more generic, just one-pagers, because banks feel a little bit more secure in those. But generally speaking, as a rule, we recommend with our clients that if you're using powers of attorney, come in and re-sign them every few years, every 3 to 5 years. Even if you're not changing who you're naming as your agents, come in and sign one with a more recent date, just so that we have a little bit more of a comfort that when we need this, the bank is more likely to honor it. One potential drawback of powers of attorney is that there's no third-party oversight. Sometimes that's the attractive piece of a power of attorney. No third-party oversight. We're not taking it through a court, so we don't have to get additional permissions and things like that as we would in a guardianship. But that can also be a downside, because if you don't have people around you that you trust or that are trustworthy to serve in those roles, and there's nobody providing oversight on that, it can be a recipe for disaster. So even without that formal third-party oversight, there's ways that we can bake in a little bit of accountability, maybe among other family members, or the ability to, your requirement to share records, or ability to audit records and things like that, to make sure that there's some sort of check and balance. But generally speaking, there's nothing from a standard that says, hey, this has to happen. So we don't always have that third-party oversight. And oftentimes in a power of attorney, there's no method provided to determine incompetency. So this becomes really tricky in situations where we don't have clear incapacity determination. So I see this a lot with some of my elder law clients, where maybe we have somebody that's dealing with dementia-related illness, and their capacity is declining, but maybe they're on that bubble where they're still competent, but maybe not competent for all things all the time, right? And even when somebody is fully, pretty thoroughly incompetent, they might still present as though they are competent. They can still speak intelligently, they can still communicate, and they can still fool you, essentially. Fake it till you make it kind of situation. And in those situations where there's not a formal declaration of incapacity, we can't override a principal's decision just by using a power of attorney. So this is really tricky because it's that delicate balance that we have to navigate with many families that, yes, mom might be slipping, but just because she's not just because she's not making the decisions you would want her to make, or maybe even not making the decisions she might have made 10 years ago, um, if she still legally has capacity, then she is allowed to make decisions, even bad decisions. And so that's really difficult for many people to accept when if we're not quite at that level of, formal legal declaration of incapacity, then it can be a really difficult balance there. And to clarify on that, the formal way that somebody is declared legally incapacitated is through the guardianship process. So you might have a diagnosis, you might have all the outward signs of incapacity, you might even have 72 doctors sign a letter saying this person is not competent to make decisions on their own behalf for healthcare or for finances or whatever. But until we have a court order that has made that declaration, then there is no legal declaration of incapacity, and that court order is obtained through the guardianship process. Okay, so something that's a little bit tricky. We usually think of capacity as something that's determined from a medical perspective, but it is something that is more determined from a legal perspective, with medical proof as evidence of what's happening. And we'll get into that more when we get to the guardianship process, and I'll explain how that all plays together. But with powers of attorney, this is usually where we like to start. If there's a prospect that a power of attorney is going to be able to be used, that this person is competent to make these decisions, that's where we want to start. It is a less intrusive alternative than going through the guardianship process. So wherever these can safely be used, we like to start here. And with many of my special needs families, especially where we have, kids that are turning 18 who need a little extra support, but maybe are just a little slower in gaining some of that independence and gaining some of that maturity that's needed to make some of those decisions, but probably not quite at the level where we would be able to have that legal declaration of incapacity, or families maybe just don't want to go down that guardianship road yet because they want to try to preserve that liberty as much as possible. I have a lot of times that families will start on the power of attorney side, and we might use them as a trial basis. Powers of attorney can be really powerful to use along with supported decision making. So where we're able to pull a supported decision making plan around a power of attorney structure, it can be a really powerful way to protect that individual's participation in their own plan and their own liberties, without necessarily having to go the extra step to guardianships. So, and in cases where I've had powers of attorney as our first line of defense, we have had situations that, okay, we tried it for a couple years. It's not solving the issues that we need to have solved. And so in those cases, the family said, okay, I think we need to go back to the drawing board and determine whether a guardianship is appropriate. In this case, that this is not successfully working. They've shown that they're not capable of handling this on their own, even with the support of a power of attorney. So we needed to go a different route. So again, we always like to try to start here wherever we can. Sometimes it's not an option, and that's okay. But it's part of the conversation so that we can make sure that we're not going to an extreme that we don't have to go to prematurely. So when do we look at guardianship? So when these powers of attorney, there we go, are not going to work for what we need, maybe the person isn't competent to sign it, or we need to do something against their wishes. If we've got that person that's kind of on the bubble of incapacity and they're, not safe to live at home anymore, we need to have them move to a care facility, but we have to do so against their will. Sometimes care facilities will not accept them without a guardianship. So if we're having to do something against their will, even though we have a power of attorney in place, sometimes we still need a guardianship coupled with that. Or if we need to get to the point where we have to override their bad decision making, things that are dangerous, they're being financially taken advantage of or doing things that are dangerous for themselves, then there's we need to shift our course here and look at better ways to protect them and provide for them. Other things that we look for in the context of all of this is powers of attorney might be great, but only when we have the right people to help make it work. So if we have predatory individuals around that person, which can be a huge concern, people that are going to exert undue influence upon them or use these as opportunities to abuse or exploit somebody, then oftentimes we're needing to get court involvement so that we're able to protect that person from some of these other nefarious presences around them, so that we're able to ensure that those bad actors are not going to be controlling the situation. So there's a delicate evaluation that needs to go in. So it's not just like I said, it's not just filling in blanks on a form. It's a counseling session. It's getting to know the family. It's getting to know the goals and the dynamics and how things work so that we can help evaluate what seems to be the most appropriate way to go. And we're not just jumping into something prematurely. Okay, so if we determine that a power of attorney is maybe not suitable, our next step is to evaluate guardianships versus conservatorships. I'm going to start on conservatorship real quick. Conservatorship is the process. It's a probate process where we're having somebody appointed as the conservator for an individual, that the court's giving that person authority to act on behalf of this person. But the difference here is that in a conservatorship, the subject of the conservatorship is competent. So there's no declaration of incapacity. So think of this almost as a voluntary guardianship. These are not frequently used. Typically we see them in the context of somebody who maybe has severe physical disabilities or physical limitations where they're not able to easily go out and do things on their own behalf. So it would be beneficial to have somebody serve as their conservator and be able to act on behalf of them. But we also want that third party oversight of the court. We want there to be a little bit more of a structure around it rather than just that power of attorney option, which is done completely outside of court. Guardianship is what we see more commonly used in the probate context. So this is the process of managing the person and or estate of a minor or of somebody who is mentally incompetent and over the age of 18 with probate court supervision. So we're going to talk about how we shape these and what the different terms mean as far as person versus estate, but there's a process that's involved here. It's not just an automatic thing. We have to apply to the court. There's a hearing that will go through what that process looks like. So the court is the one that ultimately appoints somebody to serve as the guardian. And in order for a guardianship to be instituted, we have to prove to the court that the subject of the guardianship is mentally incompetent and that the applicant for the guardianship is the best person for the job. So we'll go through some of that criteria and what that process looks like. Okay, so little vocab lesson just so that I'm not losing anybody with what I'm saying. The ward is the person for whom the guardianship is being sought. So if I have maybe some developmental disabilities that have made it to the point that I'm not capable of making some of my own decisions for healthcare or for finances or whatever, and I'm getting ready to turn 18, my parents are seeking a guardianship for me so that they can continue making my decisions. That makes me the ward. I'm the subject of the guardianship. The applicant is the person who's applying to be the guardian. They're the applicant until they're appointed as the guardian. So they're just prospective until the court says that they are the actual guardian. And the guardian then is the person that the court ultimately appoints to serve in that role with court supervision. So in all of these cases of guardianship, what ultimately happens is when a court determines, okay, this person is mentally incompetent, they need somebody to make these decisions on their behalf. This is the person we've selected as the best option to do this on behalf of the ward. What happens is that the court itself is becoming the superior guardian. So Ohio law says that any ward who is under a guardianship, the guardian is ultimately the court. The guardian, the individual that's named as the guardian, they serve as almost a liaison between the ward and the court. So they're the court's eyes and ears, they're their boots on the ground implementing this, but their authority comes from the court and they cannot do anything outside of that authority. So I'll talk through what that process looks like, but oftentimes when there are decisions to be made, many of those decisions have to go through the court first, so that the court, as the superior guardian, can make sure that things are happening in the best interest of that ward. So, goals of our initial guardianship process. What we're ultimately evaluating first, because this is what the court is ultimately going to evaluate in that guardianship first, is whether or not the ward is incompetent. Whether or not they have the mental capacity, the capability of making well-reasoned decisions regarding their healthcare, regarding their living situation, regarding their finances, and just managing all that life has to offer us. There are different levels of capacity and competency, so certainly it's not a black and white thing, and this is oftentimes the trickiest piece of a guardianship, because we have to be able to prove this, which I'll talk about how we do that. But guardianship, if the answer to this first question is no, is the ward incompetent? No, they're competent. Then we stop there. We can't pursue a guardianship if the ward is still competent. So that's the first question we need to answer. Okay, so now if we've determined, yes, this person is incompetent, we have to decide, are there any less intrusive alternatives to a guardianship? So maybe this ward is incompetent, but previously when they were competent, they signed a power of attorney, or they signed a trust. They have these other estate planning methods in place that are able to provide for these needs without necessarily needing the guardianship. The idea here is that Ohio law wants us to limit our guardianships as much as we can. A plenary guardianship of, giving somebody the authority to make all of my decisions for my personal health and care, as well as all the decisions for my financial matters, it's a very, very big deal. And so the court always wants to evaluate, are there any ways that we can limit the scope of that? And are there less intrusive alternatives to doing all of this so that we are able to rein it in and protect the ward's independence and liberty as much as we can? So we've determined the person is incapacitated. There aren't really any less intrusive guardian or options to guardianship. We've tightened it up as much as we possibly can. Then they determine, is the applicant themselves, is this person the best person for the job? Maybe we might have competing applications. There might be more than one person that files for this. And in that case, the court's then determining which one is the best person for the job. But just because you apply doesn't always automatically mean that the court is going to appoint you, because we have plenty of situations where somebody applies for guardianship. The court determines that the first two criteria are met, but they determine based on their evaluation, this person isn't an appropriate guardian. So we might need to then do some searching as to who might be more appropriate to step in on that, because ultimately it all centers back to what is in the best interest of the ward. And that is paramount. Every single layer of this is going to center back around, how do we protect that person's best interest and make sure that they are provided for at the highest level that we're able to provide. So incompetent, this piece, like I said, is very, very tricky. This is Ohio's definition. This is the statutory definition of incompetent, and I don't love it. I'll be real honest there. So Ohio law says that a person is incompetent means any person who is so mentally impaired as a result of mental or physical illness or disability or mental retardation, or as a result of chronic substance abuse, that the person is incapable of taking proper care of the person's self or property, or fails to provide for that person's family or other persons for whom the person is charged by law to provide, or any person who is confined to a correctional institution within this state. My issue with this definition, most of it, it's wordy, most statutory things are, but my big issue is that it lumps in physical illness and disability with mental illness and disability. And I think oftentimes this is why some guardianships are misused. I've represented prospective wards in the past that have had a guardianship filed against them, and they are somebody who presents as incompetent because of physical disabilities, but mentally they were still sharp. They were still capable, but they weren't able to effectively express that, maybe communicate that because of physical limitations that they had. So I really wish that the physical piece was taken out of this, because really the focus should be just on the mental capacity to make those decisions and carry out their own issues. But nobody's listening to me on that. So it's something that we oftentimes have to bring up with the court when the wrong guardianships are taken to court. The guardianship process, so like I mentioned a moment ago, when we enter the guardianship process, it's not just about the applicant. It's not just about the applicant's tasks with gathering all of this information and all of this proof. The other side, the other party to the case, if you will, is the ward. So a ward has the right to stand in and prove that he is mentally competent. So that example I just gave you of my client who had some pretty significant physical disabilities but was still mentally competent, what we had to do was present contradictory evidence so that the court could weigh the two and decide which side was more credible. So we had to present evidence, medical evidence of capacity to show that this person, while they have difficulty communicating and they present as incompetent, they are still capable of rationalizing and making these decisions. And that's important because whose interests are we trying to protect? The ward. So we need to give them the opportunity to have a voice in this process and make sure that it's being done the right way. They have a right to an attorney, they have a right to present witnesses, and they have the right to present any other evidence that they need to present to make sure that the court has the full picture before any decisions are made. Okay, so when we're looking, let's say we've gone through this whole evaluation, we've determined, a guardianship is the right way to go. This is the route that makes the most sense for my loved one. First, we have to decide what type of guardianship. So there is that plenary guardianship that I described earlier, which is appointing somebody as my guardian for all purposes, to make healthcare decisions, to make financial decisions without limitation. The court and Ohio law favors limited guardianships. So wherever we can, we try to limit the scope of that. Maybe to say, well, I need somebody to make all my healthcare decisions, but I'm still capable of deciding where I live. Or I need somebody to participate in this piece, but not this piece. So we try to learn more about the person and limit the scope of that guardianship wherever we can. This person might not have the mental capacity to make these decisions, but they're still capable of driving, or they're still capable of, getting married or voting or things like that. We look at whether we need to do a guardianship of the person and the estate of the ward, or do we need to focus on one or the other. So a guardianship of the person is appointing somebody to make all the personal decisions for that ward. Again, limited however we can. So that's healthcare, that's medication, that's procedures, that's living arrangements, that's school district, that's participation in IEPs and all of that, that whole process. So that's the guardianship of the person. Guardianship of the estate is everything that person owns, okay? What we oftentimes see with our loved ones with developmental disabilities as these kiddos grow up and reach the age of 18, they might not own very much, and that's okay. Most of the time in those situations, we're just going with guardianship of the person only, because we don't need to institute a guardianship of the estate if they don't own an estate. If it's that, hey, I've got an 18-year-old kiddo that I need to take guardianship of, and they're going to be receiving SSI, so they're going to have money coming in, that's okay. SSI doesn't necessitate a guardianship because we can have somebody appointed as that person's representative payee through the SSI system, which can be done outside of the guardianship process. So oftentimes in this context, we're able to focus on a guardianship of the person, which is a simpler process. There's a little less paperwork, a little less accountability with the court, but we look case by case to make sure it makes sense for what the family needs. Oh, I'm sorry. There is also an emergency guardianship. These are very seldom used. They can be really powerful when we need them, but they're not something that are used very widely. It has to be a true emergency. So in a situation where a true emergency exists, where there is an imminent threat to the health or financial well-being of that ward, we can apply to the court to have somebody appointed as a guardian right away without the full due process of a hearing and everything like that. We still have to show evidence of capacity and all of that in order for this to be implemented. And when an emergency guardianship is issued, what happens is that emergency guardian is in place for 72 hours, and within 72 hours, a hearing has to occur. So the court requires that a hearing occur within the 72 hours, and it can be extended for up to 30 days. So that emergency guardianship can continue for 30 days, but within that 30 days, a full guardianship application has to be filed and the court has to go through the full process. I apologize. I apologize for that. So we talked about guardianship of the person, guardianship of the estate. If we do have an individual that owns things, that's when we need to use that. The emergency guardianship, used a little bit more sparingly. We have to prove that there's an actual emergency, and different counties have different, I don't say criteria because there's not really a written criteria. They have different thresholds for what constitutes an emergency. There are some counties that we really have to prove a dire emergency. Some counties are a little bit more freely generous with the emergency guardianships, with a little less of that proof. So it just kind of depends on the circumstances and what makes the most sense. But when we decide that we are pursuing a guardianship, we've determined what type, then we have to start the process. And there's a lot of forms involved. As you can imagine, it's a court process. There's a lot of paperwork. Every county does do this a little bit differently. So you want to apply for guardianship in the county where the ward lives. That is the appropriate county to use as the venue. And I would start by looking at that county's probate court's website. Every county kind of prescribes their own forms. Many of them use state forms. They might share forms. Many counties, especially in our local area, will even provide a checklist of the different forms that need to be prepared for each type of case, so that there is a little bit of a to-do list, a task list to make sure that you've covered everything. But generally speaking, there's an application that gives info about the ward. It gives information about the applicant, the relationship, and the dynamics and why this is even being brought before the court. There's a statement of expert evaluation. And this is provided by a physician who has examined the ward in person within 3 months prior to the filing of that application. So the timing of that evaluation is really important. So usually when I've got families calling and saying, well, I've got a kid that's turning 18 in August and I know I'm going to need to file for guardianship, when do I start the process? We like to meet with them 3 or 4 months maybe before that 18th birthday to give the lay of the land, help determine what we're going to do, and then help them gather the information that they need, because sometimes it takes a little time to get that doctor's appointment. We know that you can't always get those, on demand. So having the time to get that statement of expert evaluation completed by the physician 90 days before the application is going to be filed, or within that 90 days, is really important. But that's the trickiest piece on the timing side of things. If we're doing a guardianship of the estate, we have to get a bond for the person, that's the applicant. The bond is basically an insurance policy that we're having an insurance company issue, and it has to be double the value of the ward's estate. So if the ward has a bank account worth $200,000, the bond has to be worth at least $400,000. And this is the court's way of ensuring that if the guardian does something bad, the ward's going to be made whole, that this insurance company is going to pay back essentially the ward if the guardian doesn't do what they're supposed to do. In every case, we have to have a background check completed, and so there's a process that we use for that. So we'll give clients forms to say, okay, here's where you go, here's the level that you need. Some counties have you send it directly to the court. Some counties want it submitted with the application, so we have to look to the county-specific preferences and requirements on that. But sometimes that background check can take some time too, so that's another good timing piece that would be my encouragement, to make sure that this is done without it being like a last minute, oh gosh, we're turning 18 next week type of situation. We also have to notify next of kin. So there's what's called a Form 1.0 that we have to submit that lists the names, birthdays, and contact information of all of the ward's closest living relatives. Now, closest living relatives, if the ward has parents living, it's their parents. If parents aren't living, then it's going to be siblings and nieces and nephews. If they have children, it's their children. So we look at the family dynamics and figure out who needs to go on that, because those people will all be notified of the filing of the application. Oftentimes we like to have them sign something in advance saying I'm aware of it and I'm okay with it so that the court knows it's not going to be a contested matter. But it's important to notify them so that if somebody is doing something nefariously, everybody's aware of it and can bring that to the court's attention if need be. And then whatever else the court needs. So like I said, county by county, they might ask for different things. Sometimes there's supplemental information that we have to file, but we want to look to the county specific requirements of what we need to file. We take that all to the court, we file it. We cannot file it until the 18th birthday. So we file it either on the birthday or soon thereafter. And once we file it, then the court is going to set it for hearing. Some counties will have us schedule the hearing right then and there. They'll say, okay, we're scheduling 6 weeks out, or we're scheduling 4 weeks out, or whatever that might look like, and give us some dates right then and there. Sometimes they process the application and then they'll call us back and say, okay, here's what we're looking for as hearing dates. But that's going to be our next step, is getting that hearing on the calendar. It's always going to be at least 2 weeks out, if not longer, because in that intervening time, the court itself has steps that they're going to take. So one of the most important steps is that the court is going to send a court investigator out to meet the ward. So this is a very relaxed and informal thing. It's not a scary investigator coming to scare anybody, but it's somebody from the court that comes to, first of all, notify the ward that this guardianship has been filed, answer any questions that they might have about guardianship so that they're aware of their rights, because we talked about, remember, a ward is entitled to an attorney. They're entitled to contest it. They're entitled to present evidence. And that way they're aware of what's going on so that they can exercise those rights if need be. But it's also the court's way of getting their own eyes on the situation and helping the court understand the dynamics of the ward. They're not long conversations, but they will, talk about the family, talk about, what do you do for fun? How's school going? All of those kinds of things. So the court can get a better feel for the ward's capacity from their own perspective as well. That court investigator will write an investigator's report, which will become part of the record on the case that the judge will use at the hearing to make the determination. So let's talk about the hearing. Now, when we get to that point, one thing I love about guardianships, because I'm not a litigator, I do not spend time in court. If I'm in court, there's something wrong. The guardianship process is usually the only time I'm in court, and it's not a formal hearing. I mean, it is a formal hearing in the context of it's something that's required by law, but it's not structured as formally as many legal proceedings are. The courts intentionally try to make it very relaxed, especially in situations where we're just dealing with parents applying to be the guardian, continue to make decisions for their adult child who might have developmental disabilities, and they just need to carry forward with their parenting abilities. In those cases, especially where it's not contested or anything like that, it doesn't have to be a scary thing. Now, I know it can be scary just because you're going to court and it's not something you do all the time, but the court really does a good job of trying to relax that environment a bit, make it more conversational and a little more casual. The judge or the magistrate, depending on what county we're in, will run the show, and essentially usually they start by having everybody present their appearance, which basically just means state your age state your name, sometimes your address, and why you're there. I'm the applicant, or I'm the parent, the other parent that's not the applicant, or all of that. They will always talk to the applicant first, and just say, hey, why are we here? Tell me about your kid. Tell me about what brought you here. Tell me about all of the things that you've already given as information in the application. They might pull out specific pieces and say, oh, you said that he likes to do this. Tell me more about this. And it's just the court's way of learning more about the situation and make sure that they have a full picture before they make a decision. They're going to have that same conversation then with the ward. So if the ward decides to come, many of the kids that I help represent do come, and it's a lot of fun. It's a fun experience for them to be able to see the court and see the courthouse and, maybe get to tour around a little bit. And like I said, since the judges do a really good job of making it more casual, it can be a really cool experience for them. So if they're there, the court's going to talk to them too, to the extent that they want to talk. They can, tell the judge all about themselves and about their parents and, what they like and everything. So there's that opportunity as well. And then the final decision is going to be made by the judge. So usually in most situations, where it's uncontested and we've got clear evidence that's been presented, most of the time the court is going to make its determination right then and there in the hearing. They're going to say, yep, it looks like mom's the appropriate person. This is great. We'll issue these letters of guardianship, and they'll explain the guardian's oath and guardian education and all of these things that we're going to talk about in a moment. And so usually that is a very informative hearing, and usually that's the last time we need to be in court formally for most guardianship cases. One thing I wanted to highlight for a moment that I realized I didn't touch on in the last slide is we talked about the type of guardianship, but we didn't talk about who is the applicant. This is a tricky thing that is also very county specific. So one thing that, and I see that Diane asked this in the chat, Greene County does allow co-guardians, many counties do not. So while it might naturally make sense for both parents, you know, especially if they're still married, living in the same home, all of those things, it might naturally make sense for both of them to be guardians. Not every county does permit that. So to my knowledge, and this can change over time, of course, as judges change or minds change, Montgomery County does not allow co-guardians. Greene County does. I believe Warren County does. I think they might have some limitations. But this is a stumbling point for many families, then having to decide, well, if we're in Montgomery County and they don't allow co-guardians, which parent is it? The other parent's going to be the backup, you know, all of those things. But it is a little bit tricky, and I know can be frustrating, but it does matter county by county, judge by judge, as to whether or not that's allowed. So that is an important thing to evaluate at the outset. And that also can be tricky when we have parents who maybe are not married or not living in the same home. Which one of them should be guardian, right? That might not be a good co-guardian situation, even in a county that allows it, but we need both parents on board with the plan. And so it's a conversation to have at the outset. So it's not a conversation you're having in front of the judge with competing applications. Wherever we can, we try to work that out ahead of time, get everybody on the same page as to who's going to apply for guardianship. But certainly, you know, should it come to it, if both people apply, then the court's going to have a more formal hearing, let both people present their cases, and then the court will decide. Or the court may decide neither of you, and we're going to do a neutral third party as the guardian. So there is always that possibility that I always caution people to be aware of as well. And I have seen it happen even in situations where the applicants are the parents. So keep that in mind. So if we've gotten through the guardianship hearing, we've got somebody appointed now as the guardian. The next step is guardian education. So Ohio law says that there's a 6-hour initial course that is mandatory for guardians to take. And then every year after that, they have a 3-hour like refresher course that they have to take every year. Many courts will defer this education requirement when we have parents that are serving as guardians of their adult child. This does again shift time to time. Last I was in Greene County, their tactic was to defer the education at the outset, not require you to take the 6-hour or the ongoing 3 hours, as long as you remain in compliance with the continued reporting that we're going to talk about in a moment. So at the outset, that was off the table, and you only had to do it later if you weren't following the rules. Montgomery County, the last several I've had in Montgomery County, they were still requiring the 6-hour course, and in some cases I had them still requiring the first 3-hour course. But after you completed those, then you could put in for a deferral of the ongoing 3-hour courses. So it does depend on the county specific preferences and how they handle that. But most of the time we can get that deferred to some extent, because as many judges say, how am I going to teach you something that you've been doing the entire life of this individual? So there's nothing we're going to educate you on more than what you've been doing. But you know, where the rules aren't being followed or where things are getting shaky, then it can be a really valuable tool to make sure that things aren't going to fall through the cracks for that ward. Beyond the guardian education, there are continued reports that are required, and these reports vary based on the county and based on the type of guardianship that we have. So there is a guardianship plan that needs to be filed to show, like, hey, we're actually looking at the best interests of the ward. Here's what that looks like. Here's how we are making sure that we're planning for and protecting that person. what kind of activities, what kind of education, all of the things that they need to be aware of so that this ward is being taken care of. Some courts require that to be updated annually. Some courts do it every 2 years. So depending on the court's preference. Guardianship report is basically a report on how the plan went. So I followed the plan with what I'm going to do. Here's what I actually did. How often did you actually see the ward? Making sure that there's contact, there's communication. How's the ward doing? Has there been any change in their condition? Has there been any change in their living situation? All of those things. Most of the time, so Ohio law says that with that initial guardianship or with that annual guardianship report, you also have to file an updated statement of expert evaluation. Many courts will also waive that as an ongoing requirement if the condition is such that's it's not likely to ever change. If the condition is going to be pretty much stable for that individual's lifetime, many times we can get that deferred, but it is something we have to request of the court. Some courts, Greene County, I know, will waive that kind of right off the bat. Some courts say, no, go ahead and file one, and then we'll talk about waiving it in the future. So again, according to their preference. If we are dealing with a guardianship of the estate, then within 90 days after that guardian is appointed, we have to file with the court a full inventory of what that ward owns. So, hey, here's every bank account they have, here's where it's at, and here's how much it's worth. Here's the real estate they have, here's how much it's worth, so that the court has a full picture of what is subject to that guardianship. And then the guardian can then take control of it and get it into the appropriate guardian accounts. And then for guardianship of the estate, we have to file either an annual or a biennial accounting, depending on the county, depends on the timeline. But that accounting has to show basically down to the penny every red cent that went in or out of that estate. So every bill that was paid, every piece of income that was received, so that they can see that everything was being done in the best interest of the ward and that it was all being used to their benefit. Now, with that account, another thing that's important to keep in mind, if I have a guardianship of the estate, if I'm the guardian, I can't do anything with that ward's money without the court first telling me that I can. Okay, so every time I want to spend something for the benefit of my ward, I have to go to the court and get permission first. So if I have things that are kind of like an ongoing expense that I expect, I'm going to be paying this bill monthly, or this is something I know is coming up every other month, or just those ongoing normal expenses, I can submit those to the court as a, request to just have these ongoing annual expenses or ongoing monthly expenses, and that way I don't have to apply every single month. And then I'm just going back and applying as extraordinary expenses come up. Hey, like, hey, I want to send them to camp, or I want to get braces or whatever the case might be. I have to get the court permission for any of the expenditures there. With the guardianship of the person, you don't have as much that you have to be asking the court permission for, but the big one is if you are going to move the ward to a more restrictive setting, the court has to approve that in advance. So what that would look like if I have a ward that's living at home, maybe living at home with mom and dad, but then based on the ward's medical needs, it would be more appropriate to move them to some sort of intermediate care facility or assisted living facility or something like that. I can't do that without the court's prior permission, because that's a more restrictive setting and they need to make sure that the ward's best interests are being protected there. You also have to, in any context, inform the court anytime an address is going to change. So even if it's not a more restrictive setting, but hey, I'm just moving down the street or I'm buying a new house across town, if the ward's address or the guardian's address is going to change, you have to report that to the court pretty promptly so that they can stay on top of what's going on with the ward and with the guardian. So that's the overview of the guardianship process. Now, real briefly before we end, I want to remind you not just to focus on what to do for your kid, but make sure that your own plan is in shape, because this bears a direct impact on your kiddo and any other children or loved ones that you might have as well. So having a plan for the caregiver, we all know that the caregivers oftentimes put themselves on the back burner and focus on those that they're caring for, but it's just as important to have a good plan for that caregiver, sometimes even more important, because if something happens to the caregiver, and there's not a plan in place, then now we have, a ward or somebody like that who is without a plan, or without the supports around them to make sure that they have that continuing care. So focusing on this for yourself is really important, making sure that you've got the right powers of attorney and healthcare directives for yourself, so that if you're not able to make those decisions, somebody can step in and do that for you. Making sure that you have appropriate insurance, for your own, possible disability, or life insurance. If you weren't there, if something happened to you and you passed away, is there a life insurance policy that you need to purchase so that your kiddo will still have something to help them, that they can live on, hopefully structured in a special needs trust, of course, so that it's not going to impact their benefits. But thinking through those things is really, really important. And nominating in your own documents, if I can no longer serve as guardian, here's who I would want to step in. The court puts a lot of weight on what you nominate and who you think is most appropriate to serve in those roles on behalf of your kids. So don't overlook those things. Those can be really critical in making sure that you are cared for as the caregiver, but also that your kid and the rest of your family is well cared for, and that things can work as smoothly and predictably as possible. Okay, so that is what I have for tonight. I apologize for my brief interlude there, but any questions? Does anybody have any questions? Anything that I can clarify? I know it's a drinking from a fire hose situation. It's a lot of information to absorb all at once, but I'd love to hear any questions that you have.
Let me, I'm going to shut down the recording so that in case somebody wants to, just ask the question without typing, we're open to that as well. But I want to thank you, Brittany, before I close this recording. Just thank you again. You always give us such a clear presentation to such a confusing, challenging topic. So, but 1 second while I close this.